This is Bloomberg Law with June Grasso from Bloomberg Radio.
I just know that on a day like today, that redemption is possible.
35 years after they were sentenced to life in prison without the possibility of parole for the cold-blooded murders of their parents, a remarkable turn for Eric and Lyle Menendez. They now have a chance of getting out of prison. Family members have supported the brothers throughout the years, and they were in court yesterday at the resentencing hearing to testify that not only were Eric and Lyle rehabilitated, but they helped other prisoners, including by starting support groups.
Ultimately, we are here today with this result because of Eric and Lyle, because they chose to live their lives with clarity and a purpose of service that the judge was impressed by.
This is something my grandmother Joan has fought for 35 years. I really wish she was here today, but I'm really excited to give her the news.
L.A. District Attorney Nathan Hochman had attempted to block the resentencing at every turn, arguing repeatedly that Eric and Lyle had not admitted to lies told during their trial about why they killed their parents, nor have they taken complete responsibility for their crimes.
Whether it's the Menendez brothers or anyone who basically engaged in a horrific, brutal killing of their parents, shotgunning their parents over 13 times, when they were adults, 18 and 21 years old, I would have concern whether it's the Menendez brothers or anyone that fits that profile.
Both Eric and Lyle addressed the court and took responsibility for the murders of their parents and the lies they told in court. Eric said, "I have profound sorrow for the tragedy I created. I took the lives of my mom and dad. My actions were criminal, cruel, and cowardly." Lyle said, "I killed my parents. I offer no excuse, and I don't blame my parents." Judge Michael Jessic resentenced the brothers, reducing their sentences from life in prison without parole to 50 years to life, making them immediately eligible for parole. But there's still a long road ahead that goes through the parole board and the governor. Joining me is Dave Aronberg, former Palm Beach County State Attorney and managing partner of Dave Aronberg Law. Dave, let's talk about what this resentencing hearing was and what it wasn't. It wasn't about relitigating the murders, but it was about whether the brothers have been rehabilitated.
This hearing was purely for the judge to decide whether or not the Menendez brothers can be resentenced. And he heard testimony from family members and decided that in the interest of justice that the Menendez brothers would be resentenced under the rules of the time which permitted someone who committed such a horrific offense who's under the age of 26 to be eligible for parole. The thing is, at the time, they were sentenced to life in prison without parole, but now they're changing it to with parole, and now the Menendez brothers can go before the parole board to let them out early.
Nathan Hochman, the L.A. District Attorney, opposed the resentencing and attempted to block it in every way he could. Why was he so opposed to it?
He ran on a law and order platform, and he got elected to be tougher on crime, as opposed to the predecessor, Gasson, who was seen as one of those Soros reform prosecutors. So this is in line with Hochman's brand, to be tough on crime, and he represented what I consider like this, perhaps a silent majority, not the celebrities who came out en masse to support the Menendez brothers, but people who said, I remember this horrific crime, and they were sentenced to life in prison to get life in prison, and that didn't mean 35 years in prison.
The testimony was from family members of the Menendez brothers, and it was about how they have rehabilitated themselves in prison.
The family members were the biggest supporters of an early release. Now, all the family members, but seemingly one who passed away, wanted them out early. But the district attorney does not represent the victims, does not represent the family members. They represent the people. That's why it's usually the people versus Menendez or the state versus Menendez. And in this case, the decision of the district attorney was that it is in the interest of the people of California that the Menendez brothers stay behind bars.
So they were model prisoners. Apparently, Lyle had absolutely no, write-ups for violence in the years they were in prison. Apparently, Eric had one that was 25 years ago. So there really was no evidence that they hadn't reformed themselves, was there?
Well, there was a report that showed that they did have contraband inside the prison, which was a cell phone and potential drugs. That's part of a report, and whether or not that means they have not been reformed, well, when it comes to violence, they clearly did not commit anything like that in prison. They were different people behind bars. They helped others, but yet there are a lot of people who find God behind bars and they help others, and they don't get released early from a life sentence. So it seems that the celebrity in this case, the power of celebrity, made a real difference.
I wonder if this would have happened if you hadn't had that Netflix documentary that sort of introduced a whole new generation of people to the Menendez brothers in a sympathetic way.
I agree. The power of streaming, the power of celebrity. I think the Menendez brothers became a cause celeb, and as a result, they got some benefits from it. They got all this worldwide attention. They had the best lawyers possible for them, and they were able to convince the district attorney to side with them to get a resentencing. And then that district attorney lost the election, but the judge went ahead with it anyways, and now it's up to the parole board and the governor, and I think they will be let out early. I don't think there are any risk of reoffending any violent crime. I think they did get reformed behind prison walls, but on the other hand, how many other people in their situation get this benefit, get sentenced to life in prison, and they get out early because they were good prisoners? Not many, but this case was treated differently because of the celebrity involved, because of the notoriety. And that's the issue I have. I just don't think they were treated like everyone else.
But in their second trial, the judge limited the testimony about the allegations of abuse. And it's possible the jury would have come out with a verdict of manslaughter instead of murder if the abuse allegations had gotten a full hearing.
Well, that was a judge's determination at the time, and the crimes were not overturned on appeal. I mean, the proper venue, if you think that the judge made a bad decision, is to appeal it. But the appellate courts did not agree, thought that they got a fair trial. And as far as being let out, the real reason why they're being let out, apparently, at least according to the previous DA, was because of their good behavior behind bars. But there are a lot of people behind bars who act with good behavior, and they don't get let out early. The difference here, to me, is the celebrity aspect of it that doesn't exist in other cases.
The DA, Hochman, had complained over and over that they hadn't taken responsibility for the crimes. But both brothers made these remarkable statements, accepting full responsibility for the murders. Lyle said that all the choices he made were his own, including, quote, the choice to reload, return to the den, and run up to my mother and shoot her in the head. And he apologized for making a mockery of the criminal legal system by lying. Does that seem like the kind of apology that the LADA was looking for?
It does. And that's something that I thought has been underreported. I'm glad you brought it up, June, because Hochman had asked for a real apology, said enough of this abuse excuse. Take responsibility for your actions. Stop saying that you had to kill your parents because they would have killed you first. That was a lie all along. And I do believe with their statements that they went a long way towards meeting Hochman's request. And that's why I think that they will be released early. I do think that this was as close to a full-fledged apology, acknowledgement of guilt that we have ever seen from them. It was something different than before, and I think that's going to lead to their early release.
The judge called the crime shocking. He said he was also shocked by the number of corrections officials who wrote letters on behalf of the brothers, and that seemed to be an important part of his decision.
It was something that corrections officials and family members all sided with them. And I do think the celebrity part of it has something to do with it. The Netflix shows, the movement behind them, I think that did persuade people. But, I do think also there's really little doubt that they are different people today than they were back then. They were real spoiled, selfish kids who acted in a brutal, horrific way. I mean, the fact that the mother, who did not engage in sexual abuse but may have helped cover it up, but she was crawling away after being shot by a shotgun, and then the brothers went outside to reload, to continue to come in and shoot her 10 times, including in the face. There was so much blood on the scene that the cops thought this was a mafia hit, and yet they lied about everything. They went on a spending spree. Only after spending $700,000 in quick turn did they attract the attention of law enforcement, and then were eventually arrested. But they got away with it for a while. They got what they wanted, and I thought they deserved their sentence. But they are reformed, and if the system lets them out early, I don't think they will reoffend.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Dave Aronberg. We'll talk about the 3 paths to freedom the Menendez brothers have right now, and an update on the racketeering and sex trafficking trial of Sean Combs. I'm June Grasso, and you're listening to Bloomberg. Eric and Lyle Menendez have been given their first chance at freedom in decades. A Los Angeles judge reduced the brothers' sentences from life in prison without parole to 50 years to life, making them immediately eligible for parole. But there's a long road ahead. The brothers now have 3 potential paths to freedom: through the parole board, which could grant them parole, through the governor, who could grant them executive clemency, and through a petition for habeas corpus, where a judge could grant them a new trial. I've been talking to former Palm Beach County State Attorney Dave Aronberg. Dave, their clemency hearing is already set for June 13th. And as part of the clemency hearing, the parole board already conducted an evaluation to determine what dangers the brothers may pose if released. It's called a comprehensive risk assessment. Here's what LA DA Nathan Hochman said about the findings.
We have this additional new information coming in from the Board of Parole senior psychologists that have assessed that risk as a moderate risk. Not a high risk, not a low risk, but a moderate risk.
So what do you think is the best path for them to get released?
I was actually surprised when I saw that moderate risk. I don't think they will reoffend. I mean, there's so many eyeballs on these guys. They're going to go on the speaking circuit. They're going to go do reality shows. I mean, I think it's unfair because they're going to be treated in a way that others are not. They're going to get super celebrity and make a lot of money off this, and no one should profit off their infamy. But I do think that the 2 tracks will lead to their early release, whether it's the Governor Newsom track of the clemency board and then signed by the governor, or the parole board, which is what the judge just sanctioned. So either way, I think they're headed towards a release.
And if the parole board does deny parole, it has to do so for a period of 3, 5, 7, 10, or 15 years. So it could deny parole and then say, well, come back in 3 years.
I would think that would be probably the best case scenario for those who want the Menendez brothers to stay behind bars. I do not envision them remaining behind bars that much longer. So 3 years may be the outer limit.
They also filed a habeas corpus petition seeking a new trial. Is that still in play?
That was always the most unlikely thing to happen of the three choices, 3 real choices. They had the resentencing, they had the clemency, and then they had the habeas. But the habeas was sort of a dead end. The other 2, though, bore fruit, and I think that that's going to lead to their early release. But, I just have to wonder, had there not been Netflix documentaries, would they be in this situation? Had Kim Kardashian and others not taken up their cause, would they be in this situation? They committed a horrific, brutal murder and lied about it for years. And now they're ready to be released after 35 years of serving a life sentence.
I mean, new evidence had emerged. Did that play any part in this resentencing hearing?
I think it did, because the judge took everything into account. It was more than the good behavior. It was the fact that there was evidence that the sexual abuse from Jose did occur. Not conclusive evidence, but we had a letter that one of the Menendez brothers wrote to a cousin that mentioned it. There was also the Menudo boy band member who said that Jose engaged in sexual abuse with him. So, yeah, there is evidence, and that's why it could be a manslaughter case instead of a murder case as it applies to Jose. And I'm okay if they want to let him out early for the murder of Jose because of this new evidence, because they've been good prisoners. The problem I had is the murder of their mother, Kitty, who did not engage in sexual abuse. And they said, well, she enabled him. But here are their parents sitting, watching TV with their backs turned, eating ice cream, getting blown away with shotguns by these boys who meticulously planned this brutal murder. And then they went on a shopping spree after covering it all up. And the way they murdered Kitty was so horrific and so cold, and calculated, and cruel that I don't think that's a manslaughter case. I think that's a murder conviction and should stay as a murder conviction. But as I said before, this case was really never treated the same as other cases from the beginning.
We'll see what happens with the clemency hearing in about a month. Let's turn for a moment to the Sean Diddy Combs trial. It's day 3 of Combs' trial. He's charged with racketeering, conspiracy, sex trafficking, and transportation to engage in prostitution. His former girlfriend, Cassie Ventura, is on the stand for the second day, talking about her decade-long relationship with Combs that she says was plagued by jealousy, violence, and humiliating sex. The prosecution seems to have a wealth of evidence of violence, of violent acts. Is that enough in this case?
Well, it's not enough just for there to be violence. There needs to be more. And I think they have more. They've got more because they have more than one witness who's going to testify to these freak-offs. And the freak-offs are in themselves not necessarily illegal, but it is illegal when it involves involuntary sexual conduct, when it involves alleged human trafficking, when it involves a racketeering, an ongoing criminal enterprise to service Diddy and committing various crimes along the way, like arson and like obstruction of justice, witness intimidation, extortion, and all these other types of crimes that fit under the racketeering rubric. So, standing alone, maybe they're not all crimes that would have been prosecuted. The defense is that this is a domestic violence case. This is not a racketeering case. This is not a human trafficking case. But taken all together, it does look like they have enough evidence to sustain a conviction. And Cassie, taking the stand yesterday and today, has been devastating for the defense because she's the one who connects all the dots in this case. And she's been a very compelling witness, not to mention she's also 8 months pregnant. So she's a very sympathetic witness as well.
During the opening statements, the defense attorney claimed that Combs' accusers were motivated by money. And she said that Cassie Ventura demanded $30 million when she sued him. Quote, I want you to ask yourself how many millions of reasons does this witness have to lie? So we can assume that that's going to be part of the cross-examination and why she didn't report it to police and instead filed a civil suit against him.
She set this all in motion by suing him. It's something that takes a lot of courage to be able to file something, and it wasn't a money grab when you have the other party settling it within a day, like essentially to keep her quiet. So if he wants to bring up that this is a civil case, a money grab, it's going to look bad for him to say, yeah, I settled within a day. That's something you don't do unless you know you've done it. So it cuts both ways. Yes, you can say, why didn't you report this to police, and why did you just sue? Well, okay, but look what happened. She sued, and then the police got involved, and so that led to the criminal charges. It's because of Cassie that this whole trial is even occurring. And then he also lied about the physical violence. All of a sudden, he admitted to it only after that horrific video came out. That video is very telling. They played it already in front of the jury, and the jury must be appalled by it because that's the only thing Diddy has ever admitted to, it seems, is the physical violence on that day at that moment because that was the act that was caught on video.
I read that Diddy was offered a plea deal and turned it down. I don't know what he was offered, but it does seem like this defense is going to be an uphill battle, to say the least. So what's the defense going to look like?
The defense is consent, and consent is a legitimate defense when you're dealing with adults who allegedly are victims of human trafficking. If they were minors, consent is not a defense. But to get a human trafficking conviction, you need force, fraud, or coercion. Well, that's where that video comes into play, the force that was used. Her claims of physical violence are buttressed by that video. So if they can prove force, fraud, or coercion, then all you need is one victim, and he goes down. but they're trying to show a pattern of activity to get that racketeering conviction. And then there's the other charges of the Mann Act violations, which is when you take individuals across state lines for purposes of prostitution. So I think the prosecution has enough to win a conviction and to keep Diddy behind bars for the rest of his life. The defense is going to try their best to poke holes in the victim's stories and to show that this was a consensual activity, these freak-offs. But I don't know. I mean, yesterday's and today's testimony are going to continue to hurt the defense because Cassie comes across as very credible, and the stuff she's saying is so salacious that it has to move the jury.
So Diddy took videos of these so-called freak-offs, and today they showed the jury stills of them. Do you think that just seeing these graphic images will impact the jury's view of him?
There's a rule of evidence that says that the evidence is not going to be admitted if it's more prejudicial than it is probative, if it's just used for salaciousness, if it's just used to inflame the jury. But here, it's part of the charge, so it is relevant, and it is very salacious, and it will have an effect on the jury. How do you not, when you hear things that I can't even repeat on this program? It would be bleeped out. You can imagine how the jury feels that this was real life. So that's why I think that it will come back to haunt Diddy. Now, what's ironic is that our culture now, our society, is that if he gets acquitted, he'll go back to making records and being the super celebrity he is, when in any other time you would think that just these allegations, just this kind of testimony would destroy someone's reputation on the court of public opinion. But nowadays, it seems like even being infamous can get them paid.
I don't know, Dave, even if he's acquitted, I'm not sure he could make a comeback. But he certainly has the huge hurdle of a jury verdict ahead of him first. Thanks so much for being on the show, Dave. That's Dave Aronberg, former Palm Beach County State Attorney. Coming up next on the Bloomberg Law Show, we'll look at whether the U.S. Trade Court might block Trump's Liberation Day global tariffs. I'm June Grasso, and you're listening to Bloomberg. President Trump's global tariffs are facing a key test in U.S. Trade Court. A group of small businesses is urging the court to block the tariffs, arguing that Trump invoked a bogus national emergency to justify them. The businesses claim that Trump's use of the International Emergency Economic Powers Act, or IEPA, is an unprecedented and unlawful expansion of presidential authority that would allow him to impose tariffs without meaningful judicial review. The Trump administration is arguing that the president's emergency declaration is justified, saying the cumulative effects of annual trade deficits are a threat to the U.S. economy and supply chain, and further that the courts don't have the authority to review Trump's interpretation of what an extraordinary threat is. The fight could impact trillions of dollars in global trade, and comes amid a wave of legal challenges to Trump's executive orders, which are testing the limits of presidential power on everything from federal spending to restrictions on birthright citizenship. Joining me is Bloomberg Intelligence litigation analyst Holly Froum. First of all, this is a little-known federal court. Tell us about this court.
So it's the International Trade Court in downtown Manhattan, and it handles disputes arising from tariffs. So any law that provides for a tariff presumably goes to that court, although there is some dispute about whether these lawsuits are the right jurisdiction, whether the International Trade Court has jurisdiction over these cases.
The Trump administration, Eric Hamilton was the lawyer, and he claimed that the question here is a political question and that the court doesn't have the right to decide it?
That's right. So he's saying that because there's no standard about how the court can determine whether there's an emergency that meets the International Emergency Economic Powers Act standards, which is IEPA, because there's no standard, there's no discoverable standard, that it's a non-justiciable question. So only the political branches, Congress and the president, have power to decide whether this emergency, this trade deficit, meets that emergency provision in the IEPA.
How did the judges react to that, that they don't have the power to decide this?
I think they pretty much disagreed with that. I think that's pretty clear. They said that there is this provision that says, that a declaration of emergency is not reviewable. But because they put these two magic words in the statute, which is there has to be a declaration of emergency that presents an, quote, unusual and extraordinary threat to national security or the economy, because Congress put those words in the statute, it was meant for the judiciary to interpret that. Why else would they put those words in the statute? And what the government argued was that, well, that's for the president to determine. That's a limit on the president for his self-discretion to determine that this emergency falls within that meaning, unusual and extraordinary threat. But it's not for the court to decide that.
So let's talk about IEPA, the International Emergency Economic Powers Act, and the arguments over those words, unusual and extraordinary threat. Tell us what the plaintiffs are claiming here.
So they're saying that the trade deficit is a persistent problem. It definitely doesn't arise to the level of an emergency of that nature. It's been, in existence for decades. In fact, this is not the largest trade deficit we've ever seen. And so while the plaintiffs sort of had a difficult time explaining to the court what standard they would use to determine whether this is an emergency that meets this threat, he said this is so outside the definition of those words that it cannot be possible that this trade deficit falls within that definition. So the court doesn't even need to set a standard. It could just say this is so wildly outside the definition, it doesn't meet IEPA.
And the Trump administration's attorney, what was their response?
Well, he was pressed on this also, and he says it's a political question. The court shouldn't even review it. But when pressed further, and when the court said, assume that we think that we have the power to decide this, he said, well, look at the ordinary definitions of unusual and extraordinary, refer them to dictionary definitions. And he also said in prior cases, the courts have upheld those declarations.
Yeah, and so, could you tell which way the judges were leaning on that?
So I think it's hard to say. It's very hard to say. But I think the court is skeptical. We've come out and said we think that these will eventually be upheld. But I think the court is skeptical. And the court even said, Judge Rastani even said, one of the judges of the three-member panel said, what if there's a shortage of peanut butter? Is that a national emergency? Because it's unusual and extraordinary. So could the president just declare an emergency there? Like, what is the limit? And I think they're skeptical because if they bought the government's argument, there would be no limit on the president's authority and when he can declare a national emergency and what tariffs he can impose. And that's sort of what the plaintiffs are arguing. Like, this is the quintessential unlimited exercise of power.
Did the court discuss Congress and that tariffs are, within Congress's purview?
They did. They said this is, Congress's domain. The Constitution very clearly says Congress has the power to regulate foreign commerce. Congress has the power to impose tariffs, and they're two separate provisions, and they're both within, the domain of Congress. But the government is saying, well, that's true, but they can delegate that power to the president, and they have here. And they have before in terms of other statutes that nobody's quibbling about. So Section 232, which allows the president to impose tariffs if imports threaten national security, that was delegated to the president. So even though the Constitution says, yes, this is a power that Congress has, they can, in certain circumstances, delegate that power to the president.
And how have they done that in this case?
So with what the government is arguing is that with the International Emergency Economic Powers Act, they gave the president the authority to regulate imports, which includes imposing tariffs, if the president declares a national emergency that it poses an unusual and extraordinary threat to national security or the economy.
Usually, if you're asking for an injunction, the plaintiffs have to show irreparable harm. Did they discuss whether they would suffer irreparable harm?
They didn't even get into that. So that's why there's this thinking that the court is going to rule on the summary judgment, because there's a concomitant summary judgment motion, too. So for summary judgment, you just have to win on the merits. You don't have to show irreparable harm. So there's this thinking that they're just going to rule in the summary judgment motion one way or the other.
President Nixon used a similar emergency law to issue tariffs during a currency devaluation crisis in the early 70s. Tell us about that case, and is it precedent here?
So, yes, that is binding precedent. What happened there was President Nixon imposed a 10% tariff on all dutiable goods to address a balance of payments deficit in 1971. And so there was a court case that arose out of that, and the appellate court at the time, which is the predecessor to the Federal Circuit, which the International Trade Court that's hearing this dispute is bound by, the predecessor court found that under a predecessor statute that mirrors the language in IEPA, the president had power to impose those tariffs, that 10% tariff on all dutiable goods. And so that's this Yoshida case the court was talking about. And they even said, to the plaintiff, that's identical language. The court there found that the president had power to impose tariffs when the statute said he can regulate imports. And so they're bound by that. But the court even, is suggesting that there's many distinctions with that case in terms of, what's happening now.
So you gave this a 60% chance that the tariffs will be upheld. Explain, what you base that on.
The 60% is more likely than not, but it's very, very close. And the reason we think that it will be upheld is because there is this Yoshida precedent, which says that very clearly that the president has power to regulate imports, and that includes tariffs. And then the court is going to have to get into whether this trade deficit is an emergency. And though they seemed inclined to review whether it's an unusual, extraordinary threat, we think ultimately, if this goes up to the Supreme Court will hold that the president has the power to impose these tariffs, and that the court should not be second-guessing the president when it comes to declaring emergencies.
The plaintiffs asked the court to rule on an expedited basis. Are they going to rule on an expedited basis?
I think that they're going to rule relatively quickly. So this is a case that is affecting almost everyone, and it has national import. So I think they're going to rule. I've been 2Q.
There are other cases over the tariffs, including a case by Democratic attorneys general. Is that going to go to the trade court as well?
Yes. So they filed that in the trade court. There is another case that California filed outside of the trade court, which is in a federal court in California, because they're contesting the International Trade Court's jurisdiction. But most of these have been filed in the trade court, and there are pending motions to transfer all the cases outside to the same court, to the trade court.
Thanks so much, Holly. That's Bloomberg Intelligence litigation analyst Holly Froum. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.